half of them with Courtney Jones. Courtney, state your name.
Courtney Jones.
Thank you. Your Honor, today is the time and date set for sentencing. There's no factual additions or corrections we would make to the pre-sentence report. A few things, if I could comment, we'd ask the court to adopt the recommendation. In terms of the fines and costs, my client is prepared to pay.
This courtroom session starts like any other, but within minutes it reveals something far deeper. Defendants trying to balance accountability, financial pressure, and second chances, all under the watchful eye of a judge who's clearly seen it all. From full restitution payments to emotional apologies and unexpected courtroom humor, every decision here carries real consequences. But the real question is, when someone shows remorse and tries to make things right, how far should the court go in giving them flexibility? And more importantly, does paying back the money actually change the outcome? Stay with us, because what unfolds in this courtroom might challenge what you think justice really looks like.
Full the restitution this morning, but she would ask if the court would be willing to give her 90 days to pay the fines and costs.
I just want to make sure I heard you correctly. She can pay all of the restitution to
All the restitution. The one thing we're going to ask you, and I know that the court's general policy is that they would prefer to have it paid in cash. She has a certified check or money order today it's
It's a cashier's check.
cashier's check. And she's asking, when she went to get the money out for the restitution to be able to pay it on today's date, they preferred that she do it as a cashier's check. So I'm asking the court if the court would.
I don't think I'm gonna have a problem with that. It all one.
Yes, Your Honor.
Okay. That won't create an issue. They'll be able to pay a lot.
76. Yes, 76 763566.
And the only question I'm gonna have is, but it's 4 separate. Like, we can figure it out.
Yeah, they can figure it out.
They can.
Yeah.
They can.
The cashier's check is only the restitution.
Yes.
Oh, then it's not a problem.
Right.
So, Your Honor, if the court would, she was asking for a little bit of time on the fines and costs and a probation oversight.
She's gonna pay 7,600. And he wants more time on the 5 and 8. That's East.
That is me. 100%.
I think we can work.
Okay. Thank you, Your Honor. She would appreciate it.
Because, I'm more concerned generally about the restitution.
And we made that clear to her that coming today with that would be very important.
Okay.
Your Honor, in terms of what happened, she is very remorseful. She came in with the attitude when first meeting with me that she wanted to take care of this. She obviously ran into a problem with gambling that she's seeking treatment under. And so she's taking all the necessary steps. So it asked the court to follow the recommendation today.
Ma'am, is there anything you want to tell me before I impose sentence?
The only thing I'd like to say, Judge, is that I am super remorseful and I am very eager to remedy this and move on.
Sentence of the court, I'll place you on 12 months probation. I'm going to order $555 fines and costs, $300 probation oversight fees, $2,300 restitution to Shirley Morris payable to the court, $2,185.66 restitution to Daniel Sirota payable through the court, $1,600 restitution payable to Cheryl Dowson payable through the court, $750 restitution to Ned Schwartz payable through the court. The restitution, I will indicate that that's to be paid today. It may pay certified check. Okay. How much time would you need to pay the fines and costs?
Is it possible to have 90 days, Your Honor?
No.
Or whatever you allow.
It's funny.
Well,
Since you got all the restitution, just pay that balance by July 31st.
Thank you, Your Honor.
Well, There should be no use of alcohol, recreational marijuana, or other substance will be subject to random testing as requested by probation. You're to attend individual therapy with proof to probation. You're to complete 75 hours of communication or community service, with verification to probation. I'll order 365 days in jail. Credit one, the balance is just.
Thank you.
And here we go. I don't know. Sometimes I just,
So why you do me this way?
no, it
Everybody, you didn't do nobody like that but me. See,
isn't just you combination.
it's I know. I remember you called us what the dynamic duo or what something like that.
Well, might not have been that, but
But something of that line. But I say you don't remember that. He pleaded the fifth, okay, for me. Wow. Okay.
Man,
How are you today, sir?
thank you.
Wonderful.
Your Honor, Hugo J. McApern with behalf of Ms. Johnson, please state your name for the record.
Paula Johnson.
Your Honor, we're here this morning for sentencing, and the probation department did provide me with a PSIR. I have reviewed that with my client, and we're asking the court to adopt the recommendation of the PSIR. My client says she's very remorseful over this, and will do whatever is necessary to comply with the court's orders, whichever they are.
Anything you want to tell me before I impose sentence?
No, sir. I just want to pay the restitution so I can put this behind me.
Sentence of the court. I'm going to turn 18 months prosecutor deferred sentence. You're to pay $505 fines and costs, $540 probation oversight fees, $1,039.41 rest for Walmart payable through the court. How are you going to pay that?
We made a payment arrangement with my probation officer, Miss Teresa. If that's okay with you.
Okay, I don't know what that.
Didn't we make, or we said we would do a payment arrangement?
Ask the judge.
Oh, that's what you said. Okay, I'd have to ask you. Could we do a payment?
Yeah, that's
I'm
fine.
sorry. I'm sorry.
Oh, for a moment, I forgot.
Miss Teresa, I'm just getting you, I'm sorry. That is not what she said. Okay, but she, Your Honor,
Yes, ma'am.
is there any way you could see your way through to do that for me today?
What?
Let me pay restitution and go home.
I don't know what you're asking me for.
I don't know what I should ask you for. I'm trying to do the right thing. A payment plan.
Okay.
Okay. Yes, sir.
Have anything today?
Yeah, I could pay $100 today. That help any?
Is that in cash?
No, I'm sorry. It's on a card.
I'll just indicate it's $100 today. And,
Can I pay it off the card?
and as arranged by probation. Okay, because the restitution has to be paid in cash. So
So should I
yeah, you can pay the $100 today and then arrange a payment plan.
okay, so I can't pay it off the card today, is what you,
Yes.
okay. But the rest must be in cash.
The restitution has to be in cash.
Yes, sir.
$100 that you pay today will either be applied to fines and costs of probation.
Okay, yes, sir.
All right.
I could do that.
Be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete the Beyond Barriers program. No going to any Walmart in the state of Michigan. I'll set a review hearing that's to be held October 13, 2027, 9 a.m. I'll order 365 days in jail that is suspended. Thank you.
Thank you. You have a wonderful day.
Thank you so much, Judge Simpson.
Your Honor, David Chanby, Joseph Smith is coaching. State your name for the record.
Joseph K. Smith.
Your Honor, the time and date set for sentencing. We've reviewed the pre-sentence report. It is accurate. No additions, deletions, or corrections. I don't think I have ever disagreed with any recommendation made by Mr. Polari, and I'm not going to start today. She did a great job. So we think the recommendation is appropriate for the plea.
Sir, is there anything you want to say before I impose sentence?
No, sir.
Sentence of the court, I'm going to place you on probation for a period of 12 months. You're to pay $555 fines and costs, $360 probation oversight fees. When can you pay that?
How much time do you need?
Uh,
It's about $800, $900.
30 days.
Okay, do you have anything today?
Uh, was it the case that a credit card or debit card's not good here?
Oh, no, we'll take that. We'll,
Oh, so
Just
then
for
yes.
restitution, have to
Yeah.
be cash.
Okay, then yes, I could put 100 on it today.
okay. Say 100 today,
Yes.
then the balance by May 15th. Okay?
Okay.
There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete outpatient substance abuse treatment, including all aftercare recommendations, and provide verification to probation. Attend a minimum of 3 AA meetings per week with monthly verification to probation. I will order 365 days in jail. Credit 3. The balance is suspended.
Thank you, Your Honor.
Thank you.
Let's stop by and.
Court calls case People versus Glenn Carter.
Ready, Judge? Court shall fix the first assistant public defender on behalf of Mr. Glenn Carter, who is approaching the podium.
Your name, sir?
Your name, state your name.
Glenn Allen Carter Jr., sir.
Thank you.
Thank you, Judge. We have the probation. Carter believes our recommendations are appropriate. The only thing he would ask the court consider changing is that the start time for the intensive outpatient. He indicates that he is on SSI, which most of his money goes towards his Medicare and his rent, with very little left over. He likes some time to get his situation in place before he goes into the intensive outpatient treatment. How long would you need? A month or two?
Yeah, about a month or two would be good.
If the court would allow.
I don't see where I would be placing any time frame on that.
Sounds perfect, Judge. Well, he will get it done. Other than that, he asked the court to set files recommendation.
Is there anything you want to tell the court?
Yes, sir. I would like to apologize to the community and the court. I do realize that I made a poor decision. And I am remorseful for that. And I would like to say also that after watching the impact video, I would hate to be in the other person's shoes. It would be extremely devastating to me.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does both grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies intensive outpatient treatment, attendance at AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation for a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court, I'll place you on probation for a period of 12 months. You are to pay $855 fines and costs, $100 prosecution recovery costs, $100 police agency recovery costs, $360 probation oversight fees. When can you get that paid?
I would need to make a payment plan, sir.
All right. Do you have anything today?
No, I do not.
Payment plan is arranged by probation. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete intensive outpatient substance abuse treatment, including all recommended aftercare with status reports to probation. You're to attend 1 AA meeting per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. I'll continue the sober link for an additional 30 days in lieu of 4 days in jail. I want to make it very clear that I don't want any late tests.
Sir.
So if you've
Sir.
windows that you can test in, you need to follow those.
Sir.
Understood?
Yes, sir.
I'll order 93 days in jail. Credit 1. Balance suspended. Yes.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, We'll figure that out in a moment. So, Mr. Styron, we're gonna go through this again. What do we want to do in this case? You understand what you charged with, sir?
I understand what the charges are against me, yeah.
Okay,
Yeah.
look, you're gonna have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding.
You understand, first of all, that if you do indeed direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take it back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. You may need an attorney. Your fault.
That's the forensic center. They also did not sign in, nor have they responded to email.
Lauren Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Austin.
The forensic center did not sign in for whatever
Your
reason.
Honor, could we have Deputy Allen stand behind the people at the Forensic Center?
Get. All right. I'll adjourn these out until the 13th.
All right, thank you. Ms. Allen, be ready.
Yeah, now you want to be friends. Huh? Court does call the case, People versus Shaqualin Turner.
Assistant Public Defender Jay Ballinger on behalf of Mr. Turner, who approaches. We would just be asking for 2 weeks in this matter. It looks like he's matter schedule on the 5th. See if we can come to global resolution.
This case that you have today forms a bond violation for the domestic violence. Judge Barr, at my request, revoked bonds until June 5th, final settlement conference date.
This is a critical turning point in the case. Notice how the defense strategically emphasizes full restitution up front. That's not accidental. In many courts, restitution carries significant weight because it directly addresses the harm done to victims. By coming prepared to pay everything immediately, the defendant is essentially signaling accountability and seriousness about making things right. But here's the twist. While restitution may satisfy the victims, it doesn't erase the offense itself. The judge still has to weigh punishment, deterrence, and rehabilitation. So now the question becomes, should financial responsibility reduce legal consequences? Or is justice about more than just paying back what was lost?
Court to address bond with one aspect.
Yes, sir.
This case with the defendant today is a result of the bond violation. He had contact with the victim. There was a disagreement. She called the police. Sheriff's Department encounters the defendant in a different area, and he has a loaded gun in his possession. It's concealed on his person. He doesn't have a CPL. And there is no connection with our ability to proceed on this case and a domestic violence victim's participation. This case is independent. I can prove this case with the deputies. But the fact remains, he committed this offense while he was out on bond on a domestic violence case. And with the date of June 5th being the final settlement conference, I want to make sure that the defendant is still in custody for your date on the 6th. Because if you could take a look at the bond for this case and make sure that it's appropriate given the seriousness of this offense and the nature of him being brought to court in the first place.
Do you have anything to say to that?
I don't, Your Honor.
Well, here's, I guess, what my concern would be. If this carrying a concealed weapon and he's got a loaded firearm, no ability to carry it or no legal ability to carry it. And if I'm hearing it correctly, that although in a different area, he had at some point allegedly had contact with the victim of the domestic violence.
Correct. And it displayed the gun to her. There's no FA charge on this case, Rob.
I understand that, but that is a big problem. Would not be can't be a violation. What would concern me though is that this violation could have turned into something very, very serious on that domestic violence. So I am going to modify the defendant's bond. And I'm just going to let you know, young man, since at least my initial reaction to it involves the use of a firearm in a domestic situation, maybe. Defendant's bond will be set at $1.5 million cash surety. Mr. Styron, that's all I have left. Tell the jailer he's gonna have to wait. I'll come back. You just hold him up there. Maybe he'll calm down in the interim. Send over the teller back to talk to him. He calms everybody. Court's gonna stand in recess. Ooh, we gonna start with him? All right, let's do that. Court calls the case of the people versus Styron. State your name.
My name is Thomas Styron, I live in Maine.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the motor vehicle code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's 2 different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back. Maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days. Recalls case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege a count. I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree under the Michigan Motor Vehicle Code. That is a felony punishable by up to 5 years incarceration or $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court costs. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you cannot afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings, and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, And with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the
That will-
beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if they turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Steyer, and I tried to speak with him and go over it, but I'd be happy to turn that over to him at the first available.
All right, if you would either turn that over to the court officer so that they can provide that to Mr. Severin so that he has some discovery, and if you could do that today, I would appreciate it.
Yes, Your Honor.
Setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. Defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of all,
man,
watch your
beneficiary. You're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a QVA trust matter involved in this? Is my social security number attached to this at all?
Siren, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up. You will learn how to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continued.
What we've just seen is a powerful snapshot of how real-world justice operates, not in extremes, but in careful balance. Across multiple defendants, the court consistently prioritized accountability, rehabilitation, and structured consequences. Those who came prepared showed remorse and took responsibility, like paying restitution, were given some flexibility. But at the same time, the judge made it clear that rules, procedures, and compliance are non-negotiable. Whether it's payment conditions, probation requirements, or courtroom conduct, every detail matters. And that's the bigger takeaway here. The justice system isn't just about punishment. It's about enforcing responsibility while offering a path forward. If you found this case as eye-opening as we did, make sure to hit that like button, to share your thoughts in the comments, especially who you think handled their situation best. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.